It is April 10th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Ever wonder what it takes to make a judge truly lose their patience? Today, we're diving into a courtroom compilation packed with unbelievable moments that answer that very question. You'll see a defendant whose complete lack of remorse leaves the entire courtroom speechless, and you'll witness not one but two different judges unleash on bickering parents, telling them in no uncertain terms to simply grow up. From Tenant's fighting eviction to high-stakes custody battles, these are the moments that show what happens when the gavel is about to drop. Grab some face bomb protection and buckle up, ladies and gentlemen. It all starts right now.
Here on Vista versus Green Jacks.
Good afternoon, Your Honor. Attorney Samantha Sprague, 81931, appearing on behalf of the plaintiff.
I cannot hear her.
That was my fault.
That was your fault?
Yep.
It figures.
No.
All right. Counsel, can you state your appearance?
Good afternoon, Your Honor. Attorney Samantha Sprague, 81931, appearing on behalf of the plaintiff.
Your name?
Sabrina Jackson.
Good afternoon.
Good afternoon.
All right, where are we on her case?
Yes, Your Honor. There is an attorney that has filed a limited scope of engagement in this matter. We have been in discussions. There is a belief that Hawk has stated to the legal aid individual that there is a payment that's been made to the property. My client has not received that. And so we're respectfully requesting a 2-week adjournment in order for us to review that alleged payment and see if we can locate it.
Hold on. Just so that I'm clear, you believe there was a payment made?
So I filed with an exhibit before court today of the correspondence between the Hawk representative and myself. She said there was an EFT payment made on, I have an extra one here, if you had it that in time. But it was saying how there was EFT payment made on the 1st for $3,000. However, there is a check block on my account. So I guess I don't know if the payment wasn't able to be made through directly. So right now we're just trying to find out what happened to it.
Okay, so this is why, say it again, why we need Amy. Because I have a spreadsheet that they provided to me. The spreadsheet for your case, I'll make sure I'm looking, has nothing. It doesn't even say that there was a check sent and that it. Mr. Fantera, make a note of that for that next. This is precisely what I was talking about. This is just it. It doesn't make any sense because well, counsel, you think that
I did receive a copy of the email, Your Honor, and I do believe that Hawk there's a discrepancy somewhere. My client has checked their records. They do not show receipt of it whatsoever. Additionally, no promissory letter was provided to my client, which is why they had initiated the writ. We're willing to the 2 weeks.
Yeah, I'll adjourn it out 2 weeks, but just so that everybody's clear, what you're telling me would fit with what's on this sheet and not what Miss Jackson is telling me. Because she's telling me the 3,000 went. This sheet is telling me there's nothing, which is exactly what you got So, yeah, okay, never mind. I could be on my soapbox all day, and I'm just not gonna do that. Because this is a wrong way to treat people. And these people need to understand that this is a court. And I get they're trying to help folks, but they really need to help folks. And sometimes we need a real live person to help me with that. Otherwise, I'll just start evicting people and then they gotta play catch up. Okay, I'm not.
Not me. He's
Okay, not, yeah, not you.
I'm kidding. No, it's just been really frustrating. Like even for this court case, I never got anything in the mail. I never got any notifications. I've called, I reached out, it hasn't been any correspondence. I've tried to do my due diligence of what I had to do on my end, but it's scary. I have two small children now.
No,
Seeing notes like that.
that's exactly what I'm saying. Why I was kind of,
Thank you so much.
that's why I, just so that you know where part of my, I'll call it frustration comes from is there's a monthly meet first Wednesday. And we find out the courts, the judges find out by email that instead of having a real person here that can tell us something and investigate it, that we get this printout of what's going on in everybody's case. And my feeling on that is that's just wrong. Because if you didn't show up and tell me or couldn't somehow articulate it, there'd be an eviction. They don't get that.
It wasn't easy.
Huh?
It wasn't easy. It was not an easy process, but yeah.
No, I got you. And it just, no, you can send me a piece of paper, but I'm dealing with human beings and they need to realize that. So I'll just say this. 24th is my next 2 weeks out.
That's correct.
April 24th, 2026, 3 p.m. Miss Jackson, I'll just tell you this. Between now and then, certainly nothing's going to happen to you.
Thank you.
We're going to figure it all out. I'm not going to let anything happen to you.
I appreciate it.
And that's before my next meeting, which will be the 6th. So mark that date, Mr. Fantera, because they're going to hear from me. This should not happen. Ever. Thank you, counsel. Jackson, you have.
I appreciate it. But I think
Court calls the case, Asylum Farms versus Travis, is it Ackerman?
Correct.
Did I pronounce that correct?
Yes, Your Honor.
Wow.
No,
I know.
people don't.
Hey, it's
Good.
no, it's okay. It's a blind squirrel finds a nut every once in a while. And Nicole Meltzer, right?
Yeah.
Okay.
Well, it's Ackerman. It's not changed.
My wife now, yeah, we are married, so.
When did that happen?
Oh,
September 2 years ago.
2 years ago?
years ago, this September, yeah.
Oh. I think I can still say congratulations, right?
Thank you very much.
All right, where are we on this?
Your Honor, I emailed over to the court a proposed consent judgment that sets forth terms that defendants had proposed, I believe, to Patty and then also to my office. I don't know if they've had an opportunity to review that document yet, but it sets forth some payment arrangements with a final payment that encompasses the May rent. I believe it was May 15th was the final date, if memory serves me.
Yes, May 15th is the final date. Why don't I give this to you? And I'll pass your matter briefly. If you could read it, you may have to squint at small print on paragraph 10. But if you can go through it right now, that's fine too. No, that's fine. They can go through it.
Okay. Okay. Yeah, this would be the first that we're seeing this, Your Honor. So we just want to clarify a couple details. Am I correct?
Go ahead.
Is this stating that if the full rental amount is not paid by 4/20, that eviction would proceed?
No, it indicates
Oh.
that if you were to default on any of the payments, then after April 20th, they could proceed with an order of eviction. So your first payment on the payment arrangement was originally supposed to be today. I pushed it to Monday, in light of it now being 4:30. And so, your first payment would be due Monday. Your second payment would be due the 17th. Which I think was the date you guys originally put in there. If you guys defaulted on those payments after April 20th, your landlord could seek the order of eviction. If you made every single payment that's set forth in there, but you missed your final payment, your landlord could seek the order of eviction at that point, and at that point, we're well beyond the April 20th date. So they won't seek the order of eviction so long as you pay the amount that was agreed upon on the date that was agreed.
Completely understand. Thank you so much for the clarification. Yeah, I think they're agreeing to our terms.
Is that what I'm understanding? They're agreeing to our terms that we emailed?
pardon?
I'm sorry. Are they agreeing
Just-
to our terms that we emailed them?
Yes.
Okay.
Okay,
awesome.
fantastic.
Sorry. Thank
Okay,
you.
that's great.
Exactly what happened.
Okay, yeah, and being that it is 4:35, we do have my workers' comp check. We will be depositing that immediately. And yeah, so by Monday, we will have that next payment to you, Patty and team.
Okay, all right, great. You have any other, I need the judgment for me. You have any questions?
No, I just want to go on the record that my job did terminate me as I'm on workers' comp as well. So we are working on that as well. currently.
Couple slight
So
variables.
on Tuesday, they also turned me in after I broke my wrist at work. So
When did you break it?
March
broke it
30th.
March 30th.
She was terminated on April 6th.
So but
Just a slight
and a
variable, but
broken wrist.
nothing that we can't manage.
That's it. All right, so. And. So I will sign this if you have no other questions. I would advise you that you're unrepresented by counsel. You'll have 3 business days to think about this.
Okay.
If there's some legal reason, some right you didn't assert, or some confusion on your part, you could file a motion with the court within those 3 business days.
Okay.
Doesn't mean I'd set it aside, but you have that right to ask that I give you some relief from it. You understand that?
Yes, sir.
One question, where do we pay? Do we pay to the court?
Oh, don't pay me. Pay.
Okay.
Patty and the team. Okay,
Okay. sounds
absolutely. We will be doing
Right.
that. Yes, absolutely.
Absolutely.
Thank you for working with
Okay.
us. We really appreciate it.
Okay, I'm glad that all worked out for you guys.
Yes, thank you so much.
Okay, and it's Ackerman, right?
Yeah, you got it.
Ackerman, you guys have a great weekend.
You as well,
All
sir.
right.
Have a great
Yeah.
weekend.
Take care of that wrist.
Working on it.
All right. Style Farms versus Stephanie Vogel. And is there another one? Let's see. So it's Stephanie Vogel and Corey Vogel. Definitely brought him along.
Well, I had to track him down so he can help me pay this.
Okay, all right. What's the claim?
Your Honor, the total with cost $2,145.79. Your Honor, Ms. Vogel was in communication with my office and Patty regarding a plan. I don't know if it would still apply, and I'll defer to Ms. Vogel on that, but also provide an update based on the current figures. Ms. Vogel also provided a letter of intent from DHS. And that letter indicated that they were going to assist with $581.70. They identified a tenant portion of $1,729.99, but I don't think that was before Ms. Vogel made the $1,500 payment. So I think in order for DHS to release their $581.70, she needs to just pay another $229.99, and then taking into account the DHS payment, it would leave a remaining tenant portion of nope, that's a lie. Let me subtract that. 1,564.09, 229.99, 1,334.10 would be the remaining balance due, taking into account that DHS payment.
When we were here last, you told me to call Hawk.
Yes.
I did call Hawk. They are unable to help us because he's still on our lease. DHS recognizes that he's not in the home, but the Hawk won't. So what they told me was get it under 2,000 or at 2,000 and call them back. They have another program that's working with Washtenaw County
Yep.
that can help us.
Right.
So that's
Program. So you'd qualify for, God, I can't remember. I know which one you're talking about because the cap on that one's 2,000.
2,000, yeah.
Okay.
So once I get that, I planned on paying them another like 1,000 on, what was it? Well, I had plan to pay the rest of it, but if I can get some assistance and still be able to like put
That way
my house, that would be,
Self ahead.
yeah. So if they will allow me to get that opportunity to pay that to something to DHS and get this over to
Well, the 200 you gotta pay to the landlord.
the landlord, yes, and then then DHS will
Try to
get
get
their pay,
gas payment in. Okay.
yes. And then from there out, I will be able to take that ledger,
Do me a favor.
breathe.
Stephanie, do me a favor. It's been a long day for me.
It's been a very long day for me too.
Oh, and so take a deep breath. We're not leaving you here. You just explain to me what you're trying to do. And I have a feeling you all right?
No, I've had a really bad day.
Okay, just listen.
My son went to jail yesterday, so
All right,
it's been a,
let's try to just
thank you.
take this off your plate a little bit, okay? All right, so
What I'm trying to say is if I get it paid down past 2,000, then I can apply through Hawk again.
exactly.
And I
So
time.
So what you're gonna need to do is get that 200 and some in, we'll get the payment from DHS, right? And then we can see exactly where you are. And then you can call Hawk and that funding. And then part of the reason I'm calling, so part of the reason you don't qualify for the Hawk payment because he's on the lease and his income counts.
Yeah.
The other one can say, okay, he's on the lease, but
We're separate.
but it's a higher amount that can be in that household and therefore you qualify. That's the real reason.
Yeah.
Right? See, I'm smart. All right. So what we're gonna do is when do you think you can get the 200 some odd paid in?
Probably by Monday.
So you can get it in Monday. But certainly you can get it by Thursday of next week.
Oh, absolutely.
Okay. So let me adjourn this out one more week. 17th, 2026 at noon. That's at 12 noon. Okay. Once that's paid in, DHS pays in, call Hawk back. Because
They just told me as long as I'm under $2,000 that MAC program will help me.
exactly. So with the number here, once you pay the 200 and something, you're going to be under that amount. Got it? Okay. Any questions?
What was the court date again? I apologize.
On the next Friday, but it's at 12 noon.
12 noon. Okay, sounds good.
Okay.
We'll see you then.
It'll be okay?
I hope.
Huh?
I hope.
All right.
It's been rough.
Yeah, okay, but what? Sometimes the good times are good only because we've had the rough times.
Absolutely.
Right?
Yep.
Okay, Stephanie, you have a great week.
I love your shirt, by the way.
Oh, well, thank you. All right, you're welcome, sir. See, Alan, I told you. You could have told me you like my shirt. Didn't you? Oh, thank you. See, everybody likes it except you, Alan. What'd you say? All right. Is that it for my friend Patty? Okay.
Indeed.
Patty, have a good weekend.
All right, thanks, you too.
Spice Tree Apartments versus Ashley Drummer. Is she? Oh, yeah, there she is. Miss Drummer?
I'm here. I'm sorry. I was trying.
There
to
you are.
unmute.
No,
Hello.
it's okay. Hello.
Hi.
All right. Where are we on this case?
With costs, Your Honor, of $4,503.27. At the last court date, I believe Your Honor urged Ms. Drummer to get in touch with Hawk and DHS, and I think also directly put her in touch with friend of the court in light of her current circumstances.
Yes. All right. Miss Drummer, where are you?
Hello. So, can you hear me?
Yes, ma'am. We can hear you.
Okay. So, I did apply to DHS, and then I turned in my paperwork to the court for that.
Yes,
They
yeah.
they denied it because they said that my employment at the time, which was DoorDash, did not meet the requirements for me to it wasn't sustainable basically. So I did get in touch with Hawk. I had my interview with them this past Thursday, so yesterday. And she told me that I needed to have 1,400, well, the 1,403, because when I applied, the extra $100 for the late fee for April wasn't added yet. So it wasn't 45 yet. It was 4403 and I think 96 cents or something. So she told me I needed to come up with the 1,403. I did that, and it's in my account. So I showed proof to them of that. So all she told me that I needed further was that they would pay up to $3,000, but she said there's a pretty good chance that they would pay the remainder because I did show them that I had the 1,403 in an account, and I got a job with I don't have a start date yet, but I got a job that was $19 an hour, full time, 40 hours a week. So I reported that to them as well. She said I needed to have an offer letter or proof of employment with a start date and how much I would be making. So I got in touch with them, and someone was able to call me back this morning from the company, and they're going to type me up an offer letter and get that sent to me by the end of the day today. I don't have it yet. And then she told my job to go ahead and send that to them through email, and they would go further with how much they would pay, because she said that I meet all the requirements at this point. It's just I got to get that offer letter.
Boy, you've been busy, Miss Drummer.
I've been super busy. I've been super busy. I've been praying. My faith is big. I'm getting it taken care of. It's going to get taken care of.
All right. And was FOC able to help you out, or at least get a process started for you?
Yes, with friend of the court. Yes.
Yes.
Yes, they did. They went ahead and reinstated the child support. So she told me, obviously they can't make him pay, but once they tap in with the system and he's working or if he's not working, because we have a no contact order, so I have no idea if he works or not right now.
All right. Well, at least that gave you some hope too. Because that was, out of all of the other stuff, that was the one thing you didn't expect at that hearing we could do.
I did not, Your Honor. So I thank you very much.
Hey, fantastic. So what I'm going to do is I'm going to adjourn this out a week. You got did they want you to pay over the 1,400 to the landlord?
They did, but when I showed them paperwork, like my lease, it states in my lease they don't take partial payments. It has to be all or nothing.
No, they will take a partial payment.
Oh, okay. So I can do that electronically, like in 2 minutes. As soon as I get off the call.
You can do that.
You might not be able to do it electronically. And Your Honor, this is a different client than the one that has that I'm 100% certain has the inability to take a partial payment electronically.
Right.
I can't speak one way or the other off the top of my head if this one does or doesn't. So Ms. Drummer should call the management office and verify one way or the other. But if for some reason the online system doesn't allow for it, they would absolutely take a money order or certified check.
I'm sorry. Can I speak really quickly? So
yeah.
I've been at Spice Tree almost 4 years, and I've never been able to pay a partial payment. They literally won't let me because I've asked them, like,
Okay, Miss Drummer.
Yes.
Here's the other miracle. I'm ordering them to take a partial payment from you. You can tell them that, okay?
Okay.
So you just get over there and you get what you have paid.
Okay.
And then that's going to clear the way for the other type of assistance for it to take place for you.
Okay. So now what if they say they need to hear that from you or something? They won't say that?
Want to know what? They do not want to come down here and hear it from me.
Okay.
You tell them that they can call their attorney. And tell them what
Okay, will do. Thank you so much. Thank you so much. You're the best judge ever.
Well, see, Alan, I told you. Thank you. So I'll adjourn this out 1 week, 26 or 17th, 2026 at 12 noon. Okay, we'll see where you are. Keep in contact with Hawk, get that paid, and let's see if we can get this thing moving forward, okay?
Okay, is that Zoom or in person, Your Honor?
It's supposed to be in person, but
Okay.
if you send in the thing for Zoom, then that's fine. I
Okay.
saw you. You've got your kids. I saw one of them in the background.
Yes.
Looked like he was playing basketball. All right.
Yeah, and I'm shooing them away. So, okay, thank you.
All right.
All
Take
right.
care.
You too. Bye-bye.
Bye-bye.
471. Okay, matter ending in, or matter 39471. We've got Arturo Coronel and Prime Locations Incorporated as represented by, let's see, here we go. Kiviona Pittman.
Yeah, Kiviana.
Kiviana, that's right, I'm sorry. All right, and we've got Mr. Coronel in person. Come on up, sir. You can sit at either seat's fine. Thank you so much. All right, so I don't remember if folks were out of mediation by the time I started the previous trial, but what I like to do is to give everyone the benefit of me sort of going over my understanding of the case first, and then I'll turn it over for testimony. So that way everyone has a sense of where I'm coming from in my understanding of the case. So this is a request for $1,500. Which I believe reflects twice the amount of a security deposit from Mr. Coronel, who's a former tenant at Prime Locations, reflecting the security deposit. And my understanding of the timeline here, January 14th, Mr. Coronel moved out. A couple days later, there was an invoice for repair work reflecting a charge of $360. Prime Locations sent Mr. Coronel a security deposit return, essentially keeping the security deposit, not charging anything extra. That full security deposit charge was invoiced as including some wall repair, painting of doors, door trim, baseboard. That was reflected in 12 hours work at a rate of $38 per hour for that $360 charge because the work was done in-house by the landlord. The landlord also invoiced some line items for the rest of the security deposit, including some, looks like utility charges, as well as replacing the blinds and looks like a screen. And Mr. Coronel then filed suit asking for double the deposit under RCW 5918-280, which generally outlines the landlord's responsibility with respect to the security deposit. So again, that's sort of the timeline. We're looking at January 14th through, looks like roughly January 21st when the plaintiff started disputing these charges, and here we are. All right, so. With that, I'm going to swear in the parties. I'll begin with Mr. Coronel. If you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes, Your Honor.
Okay. And before you start, I have a question for you right off the bat. And that is, so you're asking for double the security deposit, it looks like. My question to you is, if you are disputing any of the utility charges that were provided in that line item you got back for the security deposit.
I'm not necessarily disputing them. Just okay. When I read the law, it said that the judge may award up to double the deposit. Right. I don't know exactly what that entails. Maybe I'm not entitled to that full $1,500. Maybe I'm only entitled to less than that. But that's just what I read when I was reading the whole RCW page and reading through it.
Understood. Okay, but the just so I could specify, there's a $27.92 charge for, and this is out of the security deposit, utility charge for trash in December, $137.57 charge for utility charge and water and sewer for December, $84.31 for the final water sewer bill, $12.60 for the final trash bill, So those utility related items, you're not necessarily
I'm not
contesting.
disputing them just because I feel like the apartment acted in bad faith. That's why I feel like I'm entitled to that 1,500.
Understood. So it's that bad faith.
That
bond,
the
but
bad
those
faith
specific
is
line items you're not
exactly.
contesting. Okay. All right. Go ahead, sir.
Okay, so I can start.
You may.
On January 21st, 2026, I received an invoice for the charges to paint the walls after we had moved out from the Carla Lacey apartments. After reviewing the lease, I noticed no mention of the walls needed to be painted on move out. The charges withheld were $360, which when added up with the utilities and everything else ended up being exactly $750. In the lease, we see language like ordinary wear and tear and move-in ready, but based on the photos, nothing seemed to go beyond wear and tear, and the house seemed to be move-in ready. All the bathrooms, rooms, kitchens, and living rooms were cleaned by move out. When I brought this up to Keviona, the person in charge of the leasing office, she claimed that the thumbtack holes in the walls what was causing the $360 charge. I explained, according to RCW 5918-280, they couldn't hold that part of the deposit for normal wear and tear, which were the thumbtack holes in this instance. After I had explained this to her, she escalated it to her management. She came back with bad news that the management too claimed that the thumbtack holes in the walls went beyond wear and tear. The thumbtack holes, they weren't in excess. There weren't like a million of them or 100 of them on the walls. So I was extremely confused. I continued to dive into my own legal research, and I realized that my rights may have been violated. So I explained to them that if this wasn't handled properly, I'd have to come to small claims courts. They said they stood firm on their decision. So that's why I feel like they acted in bad faith after I explained the law to them. They didn't make the proper correction, and they kept the charge on there, just holding that part of my deposit. So when you look underneath the website, like we were discussing earlier, it says that if they're acting in bad faith, that the judge may award the double the deposit. So to me, it appears that the property management company was just trying to minimize turnover cost by having the tenant hold that part of the deposit to paint the walls. And I feel like if this is something that's happened to me, it probably happened to a lot of other tenants at the Carla Lacey apartments. So they did end up trying to, they contacted me, their attorneys contacted me trying to give me the $360 back, but I had already spent money on the filing fees, printing evidence, getting the USB drive. So they didn't want to go any higher than the $360. So I felt like it was time to go to small claims court. And in mediation right now, Keviona said that the $360 was already off the table. So that's why we're here right now in trial.
All right. Thank you, sir. Let's see. I don't know if I have any other questions for you. And before I turn it over to Ms. Pittman, any luck on mediation?
No, Your Honor, the parties are requested.
Parties are here. Okay. Thank you for your time today. All right. So, Ms. Pittman, I'll turn it over to you. You could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
Okay. Thank you, ma'am. And for you, kind of off the bat, if you'd like to address, a question in my mind up front is I am looking at the photos provided, I think, by both parties, but I'm looking at the walls. Specifically, I'm looking at the walls in thumbtacks and kind of the scuff marks and things like that. And, this part of the dispute, I think, seems to come down to, I want to focus on, normal wear and tear versus damage in excess of that, as reflected in some of that work done in-house by the landlord's company there. Obviously feel free to testify about any matters in your defense, but I'm curious specifically as to these photos and your argument that these are more than just wear and tear. So go ahead, ma'am.
Yeah. So, I mean, typically with like normal wear and tear, if there's like a couple of nail holes, or like if we don't have to go in and like extensively paint every single wall in the apartment or every single door, then that is something that we would typically consider like normal wear and tear. So I think Arturo's argument with me in his emails was, I think he's under the impression that I was charging him specifically for like small nail holes, which wasn't the case. It was just the charge was because of the general scope of like all of the painting that needed to take place in the entire apartment. It wasn't just due to like small nail holes, which is obviously something that we don't charge for. If you like want to hang a few pictures on a couple of walls, that is a charge that the management company. But it was more so the scope and the extent of the work that had to take place in the entire apartment. It wasn't move-in ready, as Arturo stated in his argument. And then we did try to offer to get this resolved before we got to this point. We were just gonna eat the cost and take off the charge entirely. But as Arturo stated, I guess he had already filed and things like that. And so he wasn't willing to just have that painting charge removed.
And one charge that I didn't see reflected in the photos, or maybe you can point it to me. There's the $40.76 for replacement screen, second bedroom. I didn't see reference to that that cost in the move out inspection or a photo, unless I missed it. If you could maybe point me to that.
Sorry, I'm looking right now.
And I know it's a very, take your time. I know that's a very specific question.
No, that's okay. I'm so sorry. I must have missed that invoice. Oh, no, okay, so the invoice is on there. So it's from Don Massive. I don't know if you can see it, but it's the one screen for C303 at the top. So that invoice, it has charges for other things. And so we just charged them the screen replacement minus the tax, because they invoiced me for 2 different apartments on the same work order.
Okay. And what was the basis for replacing the screen?
One of his roommates that he was living with stated that her cat had pushed out the screen for one of the bedrooms. We would have just replaced it, but it wasn't in the apartment once we had got there. They didn't have the screen anymore.
Okay,
or
so
we would have
the
just
screen. Okay,
yeah,
so
the screen was
screen
gone.
just, okay. All right. All right. And Mr. Cornell, any dispute as to that screen being gone in the second bedroom?
I personally wasn't aware of that, but if it was missing, it may have been. I know there were some blinds that my cat had bitten, so those did need to be replaced. I'm not sure about anything about the screen, but it could have been possible.
Okay. All right. Back to you, Mr. Cornell. This is your petition. Well, I guess I'll give you a chance to respond, Ms. Pittman. And as to the request for double the damages, and I guess you can respond or not. What I'll do is it sounds like you've read the statute. I'm going to read it again just now that we have context here. So under the statute, again, I'm looking at what you cited in your materials, sir, RCW 5918-280. I'm sorry, 5918-280 subsection 2. That's where we get the double damages if certain conditions are met. I'll just read it. It's short. It's if the landlord fails to give the statement and any documentation required earlier in the statute, and that is the statement documenting the statement of what charges the landlord is going to apply to the security deposit based on repairs that they've identified as beyond wear and tear. So failure to provide that statement within 30 days, the landlord should then be liable to the tenant for the full amount. So there's that 30-day timeline. Where the double damages kicks in is it says the court may, in its discretion, award 2 times the amount of the deposit for intentional refusal of the landlord to give that statement, documentation, or the refund. And so, that's kind of the statute we're looking at here. Ms. Pittman, I guess for you, if you want to just correct me if I'm wrong as far as the timeline here, do I have that correct? There's a January 14th move out invoice a couple days later.
Yes.
Okay. All right. Thank you. Anything to add, ma'am, before I turn it back to Mr. Cornell?
No.
right, Mr. Coronel, back to you for any concluding remarks you'd like to make.
Yeah, just to me, it seemed like they added in bad faith. That was my understanding of kind of that subsection, like where it says at the end, or the refund. They should have just, you know, when I pointed out the loss to them, it should have just been, the 360 should have just been given back. We shouldn't have had it gone through this whole process. We should have both reviewed the law and seen what it meant, and then understood that ordinary wear and tear, I mean, thumbtacks are typically ordinary in houses. You've seen the pictures. It doesn't look like they're in excess, or it doesn't look like they're big bolts drilled into the wall. And we're pretty mindful of that. And so I just feel like when they denied me, and then she even escalated it to her management, and they denied me as well. I felt like that was just in bad faith. I felt like they were trying to do turnover costs, because usually an apartment would paint over the walls, make sure everything's clean before a new tenant moves in, because there are going to be slight wear and tears, and you want to make sure it's ready for the next tenant. Not necessarily that you have to, but usually that's what happens. And I feel like they were just trying to get me to pay for that, or get us to pay for that.
And how long did you live in that apartment?
Just a year.
All right. All right, thank you. Well, so to begin, we are talking about that statute, RCW 5918-280. And the issue before the court here comes down to whether there were charges against the security deposit for damages that are simply wear and tear. What I'm finding that the $349.55 reflecting the work done by the landlord in-house for damages it's claiming is above and beyond wear and tear. I'm finding that my review is that was normal wear and tear. I understand from Ms. Pittman's point of view, it sounds like, well, looking at these damages in isolation, it may look like wear and tear, but it was sort of more extensive throughout the apartment. That may be true. But I think on balance, reviewing the photographs here, and also the relative low amount of charges for those repairs, I think reflects that this was likely kind of wear and tear that was being mitigated here. So I do find that Mr. Coronel is entitled to that $349.55 back. I'm not finding that there's anything done in bad faith here. Frankly, whether damages are wear and tear or not, these are highly fact-specific questions. And I think that Ms. Pittman working with you and then going up to, you described it as kind of escalating it to management. It could also be viewed as her doing her due diligence and making sure that the apartment understood your perspective and that everyone was able to take a look at what these charges were. And so I think Ms. Pittman likely was doing her job. And so I don't think that anything was withheld from you in bad faith. And so I'm not issuing double damages here on that front. And I am only finding out of that invoice the invoice of what was kept and charged against the security deposit. I am finding, to me, I believe all the other invoiced items seem to be either not in dispute or reflected, pretty clearly in the evidence provided by Ms. Pittman. So I think the rest of the invoice charges are sound, and we're only talking about $349.55. So I will award that amount to you, Mr. Coronel, in addition to the filing fee for small claims and the cost of service, which was Mr. Coronel, can you point me in the direction of the cost? I have your certificate of service. Do you have a receipt for that or an amount?
I'm not sure if I remember paying the service fee.
Okay.
I remember the $50 for the filing fee.
All right. Well, without evidence before me of how much you paid for service, I'm not going to
like service here at the court.
Service when you sent sent legal service to prime locations.
Oh, to serve the paperwork?
Mhm.
Oh, that was just my sister, so.
Okay.
That was.
Okay. All right. So in the absence of service costs, you will get that $50 filing fee though.
Okay.
All right. So I'll filling out a small claims judgment in favor of Mr. Coronel for principal amount of $349.55. Filing fee $50, bringing the total to $399.55. Ms. Pittman, do you have any questions? All right, thank you, ma'am. You're free to go. And Mr. Coronel, expect a certified copy. Oh, we'll get you a certified copy today of the small claims judgment.
We'll get the certified copy in 30 days.
Okay, yeah, so okay, thank you.
Sorry.
You'll get a copy of it today and then a certified copy in the
So I
mail.
can't do anything until I get that certified copy.
Well,
They can
Yeah.
pay on it, but if after 30 days it's transcribed to a civil case, that opens up more options for collecting. But it has to wait for 30 days because of the appeal process and everything. So, but yeah, and then we'll mail you that certified copy and everything once that's all done. So, but
Yeah.
obviously, if they pay you or whatever, we're handing you reach out, let us know.
yeah, nothing stops the payment from happening now. It's just a certified copy is what you need if you need to go enforce it in various ways through another legal action.
Okay.
Okay. But we'll get you a copy of it here today. All right. Thank you for being here, Ms. Pittman, and for your response. Have a good rest of your day.
Or Michelle Hooker.
Oh, Michelle Hooker is online right now. We can't take her case.
Okay. Ms. Hooker, good morning. If you'd activate your audio and video, please. Thank you. And Ms. Clark, on Ms. Hooker's not over.
Yes, Your Honor. There should be a plea of guilt in the judge's folder for Ms. Hooker.
As well as a no contact order pursuant to that. Please.
I have both.
Perfect, thank you.
All right, Ms. Hooker, there is a statement of defendant on plea of guilty on the charge of assault. I'm going to go over that form with you.
Okay.
Ms. Hooker, it looks like Mr. Stashevsky signed this form for you. Did you give him your authority to do so?
Yes, sir.
Okay, you had sufficient opportunity to go over the form with Mr. Stashevsky?
Yes.
Any questions for me about the form?
No, sir. No, sir.
You understand by pleading guilty to the charge of assault that you give up the constitutional rights set forth in paragraph 5 of the plea form?
I believe he went over that.
Say that again?
Yeah, I believe we went over all that, yes.
Okay. Yeah,
There's like
constitutional
a
rights.
stuff.
Yeah, the right to go to trial, the right to
Yeah.
testify,
Yeah.
not testify, the right
Yes.
to appeal.
Yes.
You understand all? Okay. And are you an American citizen?
Yes, sir. Yes, sir.
Okay, thank you. And you understand in this case, the state's sentence recommendation is for 30 days in custody, the 30 days to be served on electronic home monitoring. And it looks like a 50-hour community service obligation. And then get a mental health evaluation, comply with treatment, and have no contact with Ms. Nancy Shorn. You understand those recommendations?
Yes.
Okay, I guess I think it might be Sham or Shorn. I see it.
Shorn.
S-C-H-O-R-N?
S-C-H-O-R-N, yes.
Okay, thank you. And it looks like there was damage to property in this case. Is that right?
No, it's damage to me.
Damage to
All
personal
right.
property.
I would like to speak if I could, Your Honor.
I will give you a chance in just a few minutes. Thank you for letting me know you're here on this case. And the issue of restitution would be reserved, which means the state could file a petition for restitution during the pendency of the jurisdiction of this case. And if the court orders restitution after hearing, payment of the restitution becomes a condition of the sentence. You understand that, Ms. Hooker?
Yes, he explained all that.
Okay.
When I explained to him that she would need to prove which injury caused what and what so on, and we already discussed all that.
Okay. Your statement here indicates that on the 28th of August in Thurston County, it says here you intentionally subjected another person, and that would be Ms. Shorn, I'm guessing, to an offensive touching. And Ms. Shorn found that offensive touching offensive. What that tells me in sort of plain language is that in the course of an argument or disagreement between the two of you, you either hit, punched, shoved Ms. Shorn. Are those facts accurate?
Yes.
I'll find sufficient factual basis for defendant's plea. Find the plea is made knowingly, voluntarily, with full understanding of the consequence. Accordingly, I will accept defendant's plea, enter finding of guilty based on that plea. And Mr. Olivier or Ms. Facio?
Ms. Facio.
Ms. Facio, this appears to be the only crime of violence on the record of Ms. Hooker. Is that your understanding?
That's state's understanding, yes.
And were you the one who made the offer?
I was.
Okay,
yes.
you want to explain the offer a little bit to me? Your thoughts on it?
So this offer was made in lieu of upfiling it to an assault 2. It was staffed with my supervisor as well. The incident did cause permanent damage to Ms. Shorn. And while it was filed as a gross misdemeanor, the state offered this, and if it was not accepted, then the state was going to upfile it. So the state believes this is a very fair offer for the facts of this case, Your Honor.
So the original charge was assault 2.
The original charge was filed as an assault 4. In the course of the investigation of that assault 4, some more information came to light that the injury
was substantial. And would warrant an assault 2 charge if the state chose to proceed in that fashion.
The state believes so, Your Honor.
Yeah. Committed perjury.
Right. Ms. Clark, anything on Simpson?
Yes, Your Honor. We believe it was a greatly negotiated plea and asked the court to accept the plea. Mr. Stashevsky is also asking for 45 days for Ms. Hooker to be able to complete the EHM.
And Ms. Shorn, you wish to say something? Why don't you, if you can make it up here, come stand where Ms. Facio is. There's a microphone there. That'll make it easier to make a record of what you say.
Here.
Yes, you're close enough. There we go. Yes, thank you.
Thank you, Your Honor. Yes, on August 28th, I was at Winco, and there were some circumstances I was talking to some other people about, and Ms. Hooker
came at me. I was in a cart, a wheeled cart at the time. She came at me and she shoved me back in the middle of the aisle of the parking lot. And I was always screaming. I was screaming at her, telling her to stop, and she didn't. And so I went to stand up off the walker, and she gave me a full force body blow to the ground. I have lost the use of my right hand. I will not probably ever get that back. And I wear a brace, obviously. And I've had I had numerous bruises, including a bruised tailbone, and I hit my head. And yeah, it's frustrating because I can't even drive by Winco anymore without having some sort of a panic attack. So it's frustrating that this couldn't have gone a little further than what it is right now.
All right, thank you very much. Thanks for being here today.
Last 5 seconds to how a chemical stopped.
That's not how that happened.
Ms. Zucker, let's make sure it's just you speaking on the microphone, please.
Oh, there's noise in the background. I have to have noise in the background for stuff, so my bad.
All right, Ms. Zucker, anything you would like to say?
I'm not really allowed to say my side, so I don't know what I'm allowed to say or not say because how it played out is not how it played out. I'm being punished because the deputy didn't retain information, video. He committed perjury, and I am suffering the consequences of those actions. The investigation was not done properly. I agreed to these charges just to move on with my life. I have already my documentations and the stuff from my attorney so that I can file a complaint directly with the sheriff's department because the deputy is the one that failed this. He committed perjury. There's no video evidence, so she can say whatever she wants. How that happened, what she said is incorrect. But I have no way of proving myself. Everything, all the evidence leans in her favor. So I literally accepted these charges to move on with my life.
I'm pretty confident that Mr. Stashevsky, in speaking with you, let you know that one of the things that if you get to sentencing, which we are at, that one of the things the court would be looking for is somebody who expresses regret for their actions and has some sympathy towards the victim in the case.
I feel bad, but she lied. She literally lied. I didn't just walk up to push her. She blocked a private citizen and she harassed them. She followed them from outside. She followed them from the store, crossed behind my car. The deputy was able to articulate in his police report my movement, but neglected the fact that she was following them, yelling at them. This man was begging her to leave him alone. I didn't just walk up to some random person and push her off a cart. The first incident was I pushed the cart by the basket to remove her as an obstruction. She chose to get up and hit me, push me, and then she was the one that lunged at me, tripped over her dog, and fell. But again, there's no video evidence of this because the deputy or sheriff, I don't remember his title, I apologize. I'm not trying to be intentionally rude. I don't remember if it's a deputy or a sheriff. I believe maybe a sheriff. I don't know. But he did not retain the information. My attorney tried to contact him 10 times to talk to him and still never got to talk to the deputy or sheriff. I wish I remembered his title. I apologize. But again, it's not a matter if I don't have remorse or feel bad that she got hurt, but she's not the victim and I'm not the victim. I'm accepting my responsibility. She's refusing to accept her responsibility. She tried to call APS on me. She has tried this entire time to ruin my life. I want to move on and be done with it. I've agreed to the terms. I've agreed to a home monitor for 30 days, which I have to pay for off of my disability. I'm 100% disabled, state disabled. I get Social Security, not Social Security, SSDI. So it's not a matter of not having remorse. It's just a matter of lies and manipulation in this case. And I just want to move on. If I have to accept the charges, I'm accepting the charges and moving on. And I will file my complaint directly with the sheriff's departments for his lack of his due diligence and his duties in investigating this case privately. One witness out of Winco employees to include loss preventions, but one witness favors his storyline, but didn't talk to employees, didn't talk to any of the 20 witnesses that ran to her side because she's crying, which she wasn't. But whatever. It is what it is. I'm not an insensitive person, but I don't like liars and I don't like manipulators. And she's manipulating the situation. And so it is what it is. And I'm sorry if it comes off that I'm not sincere or remorseful. I'm disabled. I have nerve damage. I understand chronic pain issues. Mine goes from my neck down my back, down my right side, down my leg. And I have to have surgery in a month on my neck. And that may not repair that nerve damage. So I understand the permanent damage. But in 3 fingers, when you had an elective surgery, and now I have to have a possible restitution because she may come after me later for restitution because of her. She had 2 elective surgeries on top of each other. She had carpal tunnel surgery plus this surgery, reparative surgery which according to the papers my lawyer showed me, weren't even necessary. She made an elective choice to have these surgeries. And now I'm responsible for them. Fine. I'm not above change. I'm not above taking accountability. I accepted the mental health evaluation. I'm fine with that. I accepted the home monitoring. Fine with that. If these are the consequences because I can't prove my innocence, then it is what it is. But I'm not going to sit here and cry and like, oh, I'm sorry you hurt yourself. Well, you're not the victim in this. You made a choice to obstruct somebody's free movement. The person literally drove through cars and 2 pillars to get away from her because she would not leave them alone. She blocked them 3 times. So I'm sorry that it seems that I'm not remorseful. I do apologize if it seems that way. That's not my intentions. Not even in a little bit. But I accepted my responsibility, and for her to get up there and lie on the accounts, lie to your face on the accounts. I can't stand by that. I'm sorry.
Okay. I can comment that you sincerely seem not remorseful, so I will note that.
Okay, that's totally fine. That's totally fine.
And Ms. Hooker, you understand that the state's indicated they were contemplating filing this as a felony charge.
Yes.
And
that's why I accepted. That's why I accepted the charges as is.
Right. So you were potentially looking at substantial jail time. You understand that?
Mm.
Yeah, I just find it interesting that in the face of that, you want to come in here and explain why.
No, I've done.
Right. Okay. All right. We're not debating it. I'm just commenting.
I accepted it. I accepted it. So I accepted the charges.
Just so you know, the silence is me considering whether I should not follow the state sentence recommendation and impose something significantly more substantial based on your response to this incident. I'm not impressed by that.
Okay.
All right. I will reluctantly go along with the majority of the sentence, 30 days in custody, 30 days to be served on electronic home monitoring. And I want you to begin serving those 30 days no later than the 15th of May.
So, what, 15th? Is that what, 15th?
15th, 1-5.
Okay.
And you're, for the next 2 years, you're to have no contact with Ms. Shorn at all. You're not to possess any firearm or other dangerous weapon. You're to have no criminal law violations.
I'm sorry, what was that about firearms?
You're not to possess any firearms.
That's not what I was told by my lawyer.
Yeah, that's fine. That's what you're being told by me, and that's what matters.
For the 2 years?
For the 2 years, you're not to possess any firearms. If you have any firearms, you are ordered to surrender them. And you're to obey the no contact order. You are to provide proof by the 11th of May. Actually, I'll make it the 15th so we don't have too many different dates. By the 15th of May that you have had your mental health evaluation and you're complying with any treatment. 50 hours of community service need to be done by the end of this year.
I was told I was given a year because of my.
Like I said, what matters is what I tell you.
And how do I get an extension? Because I do not work because of my disability.
So I've given you till the end of the year. You can get, that's less than 10 hours of community service a month. It's, you can get that done. I'm quite confident. Especially since you don't work. That's plenty of time to go get the community service done.
I don't work because of disability and I have limitations. Right.
Yeah, I'm sure you can find community service that will be adapted to the limitations that you have. All right, I've signed an order to that effect. And
then how do I resolve the gun issue after my 2 years?
This is not a domestic violence case, so there's not a lifetime ban on possessing firearms. You
No, you said I had to surrender and I wasn't allowed to. So how do I reestablish that? Is it going to be in the court papers?
No, you don't have. You just wait till the end of the 2 years. Then this obligation goes away.
Okay.
And you'll want to get in touch with Mr. Stashevsky so you get a copy of this order. You'll need it to set up the electronic home monitoring and to keep track of different dates. Thank you.
Let's go on the record in the matter of Bank of America versus Amy Wrigley, 2501182. And counsel, your appearance, please.
Good afternoon, Your Honor. Alexander Sarhan, P77252 on behalf of plaintiff.
Okay, and ma'am, if you can please unmute and state your name for the record.
Hi, Amy Ann Wrigley.
All right, thank you. And counsel, you and Ms. Wrigley were able to speak in a breakout room, is that correct?
That's correct, Your Honor. We were unable to reach a resolution.
Okay. Okay, and so ma'am, there is a motion for summary disposition. Did you file a response?
I did.
Let me just say.
Your Honor, if I may, the defendant did not file a response to the motion. I believe she's referring to her answer.
Correct.
Okay, so ma'am, my question is, did you file a written answer to the motion for summary disposition?
No, I'm sorry, Your Honor. So actually, I explained to the attorney, I would like to have this adjourned so my attorney could have a chance to look at everything. I had moved, mail was held up. I never got any of the information other than I was served the paper. I objected to it, and then I moved. All my mail was tied up. I'm actually in Florida. My friend picked up my mail on Monday. She opened it and said, "You have a court date Friday." He's also out of town. Monday morning, he can contact the attorney or the court, and he's going to represent me on this matter. All the information is not correct that the attorney has for Bank of
Okay, just a moment. First, you moved from Michigan to Florida?
No, I moved from Wyandotte to Riverview.
Oh, okay. All right. And so, ma'am, who is your attorney?
Daniel Webster.
Excuse me. All right. I don't have an appearance filed by Mr. Webster at this point. When did you retain him?
I retained him today when I found out about, I'm sorry, I retained him the day I found out about the hearing, but he's out of town also. He's also in Florida, and he wasn't able to file any motions or do anything.
Okay. All right. So, counsel, I do find that there's, I'll give you an opportunity to respond, counsel, but I do find that there's good cause to adjourn this matter, absent something that you may offer differently.
Your Honor, I would respectfully point out that if the defendant did reach out to an attorney, and that wasn't until yesterday, any response filed would not have been timely. This matter, the motion for summary was filed in early March. There was a phone pretrial that took place on February the 12th that the defendant failed to appear for. The defendant was personally served back in September, which of course is why the subsequent answer was being filed. So she's been aware of this suit for quite some time. As far as possibly moving, we didn't receive any notice of a new address. The court was unaware of a new address. So I don't know that there, respectfully, I would say that there is not a good cause to adjourn this, as the defendant has had ample opportunity, been on notice of this, did not file a response, did not appear for the phone pretrial, states as of yesterday, possibly an attorney who is also in Florida, who has not filed an appearance, who would not have failed a timely response. Again, no response to the motion, and our plaintiff's motion for summary is clear on its face with respect to the attached exhibit regarding a breach of contract, defaulting on that contract, and subsequent damages owed. And lastly, the defendant had mentioned some sort of a loan or a consolidation loan. There's no record of anything like that in her answer. Or, I'm sorry, while it's stated in the answer, there's no supporting documents, which of course would be true because there was no response filed, which is required by the responding party, represented or not.
Okay, thank you. Ma'am, when did you move?
Your Honor, yes, I moved in December. And so in December, I was served this a few days before I moved. And then my mail was forwarded.
I'm sorry, ma'am, just a moment. What were you served with a few days before you moved?
The original complaint against me. So I filed the answer, which I objected to the amount that I owed, because this should have been a part of my consolidation loan. I consolidated all my debt.
Okay, just a moment, ma'am. Ma'am, I'm showing that you were served on September 13th.
Okay, correct. You're right. I was served in September. I objected. I never heard anything back. I had reached out to the original creditor, the attorneys, to try to resolve the issue and see why this wasn't a part of the consolidation loan. And then if it wasn't, I at that time was ready to make payment arrangements or, make a way to pay it off. Well, I had contacted the attorney's office several times, never got return phone calls. I didn't know what to think. I never received anything else until Monday when my friend opened my mail and sent me this court hearing. And so I immediately called the attorney on Monday, not yesterday. And he said he was in Florida also. And there was nothing he could really do for me to ask you to adjourn it to another date so he can take it over.
Did you receive did you notify, and did you change your address? Did you change your address with the post office, ma'am?
Yes, ma'am. And all my mail was tied up. I had a forwarding address. My mail has the yellow stickers on it, but it never came to me. I never got any of my bills. I never got nothing from Wyandotte to Riverview. And I never received any motion for a phone recording. I never received none of that.
Well, there was a scheduling order that was sent out December 10th. And so it's possible that was tied up with that as well. Counsel, I hear everything you're saying. Yes, Mr. Webster needs to file an appearance. Also, Miss Wrigley is indicating that that he's also out of town. So, counsel, what I'm going to do is I'm going to adjourn this for 3 weeks to May 1st. At what time, Alicia?
1:30.
Can we do 11 a.m.? Can we do in the morning? Okay. 11 a.m. Does that work?
11 works.
Okay, perfect. Thank you. Okay, just wait in case our morning runs over. At least we don't have to. Okay, so we're going to do 11 a.m. on May 1st. Ma'am, I will not do any further adjournments if your attorney does not file an appearance. And in fact, if your attorney does not file an appearance, that will definitely have some weight against your credibility.
Thank you, Your Honor. He will definitely do that Monday.
All right, thank you. Have a good day.
Thank you. You too. Thank
Your
you.
Honor, if I may, can I just, you said May 1st, was that 11 a.m.?
11 a.m., yes.
Thank you, Your Honor. And lastly, to confirm, or just to make sure, maybe, should the attorney not file an appearance or something? Is the court now aware of defendant's new or current address? I did get it in the breakout room, but
Counsel, if you wouldn't mind emailing that to the court, she's already logged off. I wasn't quite done and she logged off, but so if you can please email that to the court so we have her new address.
Of course. May I have the court's email address? Or maybe I can find it on the website?
That's what you can, but that's all right. 27DC at wyandotte.mi.gov.
Wyandotte.mi.gov. Thank you, Your Honor. Have a great weekend.
Thank you. You as well, counsel. Okay, let's go off the record. Let's go on the record in the matter of. Oh, hold on. We're going to go off the record for a moment. All right, we're on the record in the matter of the city of Wyandotte versus David Gamet, 26466.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As the arraignment, the way formal reading, my client stands me up.
Thank you. Mr. Gamet, your name for the record, please.
David Gamet.
Right. The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on Well, April 22nd is blocked. And that gives us the 15th.
Yes, down.
At what time, Alicia?
Sorry, well,
No, that's okay.
9:15.
At 9:15 a.m. Counsel as to bond.
Your Honor, my client indicates he's not on probation or parole. He does have gainful employment. He works at Bell Tire. Judge, based on the nature of the case, he understands that he's not going to be able to leave the state of Michigan without permission, nor will he be able to have any non-prescribed drugs or alcohol. I'd ask consideration for a personal bond. Thank you, Judge.
All right, sir. Which Bell Tire do you work at? Out by you or down this way?
Down this way, but in Taylor, Eureka and Telegraph.
Have you ever failed to appear in court for any reason, sir?
No,
You're not currently on probation or parole anywhere?
no,
And you don't have any other pending matters?
no.
And how long have you resided at your home in Wayne, sir?
In 2016,
Where did you live prior to that?
Leslie.
Given the nature of the charges in this matter, the court does have concern for the safety of the public. The court's going to order a $3,500 10% bond to ensure Mr. Gamut's appearance and compliance with the court orders. You're not to possess or consume any alcohol or drugs unless prescribed, sir.
Okay.
All right, we'll see you back on April 15th. Thank you.
Thank you, Judge.
And then this is the matter of the City of Wyandotte versus Eric Januszewski, 26465.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
Sir, your name for the record, please.
Eric Januszewski.
All right, the court will waive the formal reading under a plea of not guilty for purposes of the arraignment, and then schedule this matter for pre-trial on April 15th.
Ten 10:30.
At 10:30 a.m. Okay, and counsel as to bond.
Your Honor, as to bond, my client indicates he will appear to any and all future court dates. I noticed that these are misdemeanor charges. When I asked him about financials, I know that right now he does have an opportunity for gainful employment, but financially he's not going to be able to post anything today. So I'd ask that be considered when determining the appropriate bond. Thank you, Judge.
And sir, where is it you work?
I work for Express Employment Agency for Northern Packing Company in Carlson. I just started, Your Honor. My first paycheck is next Friday.
And how long have you lived down that way, sir?
For the last 2.5 years.
Do you have any pending matters, sir?
No, Your Honor.
All right, what happened in the matter in Dearborn Heights from September?
It was closed and all processed.
If you're to test right now, sir, what's in your system?
Cocaine, Your Honor, only. I relapsed. I actually relapsed yesterday. I was clean for a year, and me and my wife almost got to a divorce, and I got kicked out, and I relapsed. But I've never missed a court date. I've never failed to appear anywhere, and I'm not trying to lose my job, Your Honor. I just started, if possible.
And so is your wife able to help you post a bond, sir?
She's not gonna help. She's making me do this on my own, and the only other person I have is my sponsor, and he's not gonna. I can't ask him for money, Your Honor. I don't know if there's a payment plan for next week or something like that, but I'd have to get back to work in order to pay anything. I don't have the ability to pay anything. But I will show up to court. I will make sure everything is clear.
Here's what I'm going to do, sir. I'm going to order that you're not to possess or consume any alcohol or drugs that are not prescribed. I'm going to order that you are to participate in random testing. The court will give you a $10,000 personal bond. You do not leave the building without stopping at probation and set up your testing. If you leave the building and do not set up your testing, sir, the court will issue an immediate warrant for your arrest. Am I clear on that?
Yes, ma'am. And that's in this building? Sorry.
Sure is. It's across the lobby from the police department.
All right, thank you.
Have a good day. All right, and then we are on the record in the matter of the City of Wyandotte versus Rebecca Attard, 26467.
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my clients. Time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
All right, ma'am, your name for the record, please.
Rebecca Attard.
All right. And the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then counsel will schedule this matter for pretrial on April 15th.
$11:15.
11:15 a.m. Counsel as to bond.
Your Honor, as to bond, my client indicates that while not working, she is a caregiver, and financially she does have some constraints, but she will appear at any and all future court dates. That being said, I made her aware that she'd most likely be subject to some sort of testing because she'd have on the liberty to any drugs or alcohol while the case is pending. I would ask consideration for a personal bond. Thank you, Judge.
Okay, I'm sorry, where are you working, ma'am?
It's not
I'm
working,
living
Judge.
with a man in Melvindale who has no fingers and has a lot of physical disabilities. So in lieu of like paying rent, I'm helping him do cooking, cleaning, laundry.
And who is that to you?
He's a friend.
Oh, and do you live there?
Yeah, I have been the last few weeks because he just needed the help. I mean, the Trenton address, it's my father's mailing address. I don't want to switch mail over to somebody's house in case it doesn't work out.
Well, then how do we know where to find you if you don't show up?
Well, I'll still be in Trenton.
Not if you're living with another individual, you're not in Trenton.
Well, I bus back and forth. I'm always walking or taking a bus, so you probably see me out there.
So, ma'am, tell me about the matter that occurred in Melvindale in 2025, October.
My friend's dad tried to gouge my eyes out, and
Hold
I
on,
got
I'm
assault
sorry.
battery.
Let me clarify.
Yeah.
I'm not asking for a factual background. What's
Yeah,
happening
it got
with that
reduced.
case?
So it got reduced to, I think it's disorderly or disturbing the peace. I'm not sure.
Okay. And what about the matter February 28th out of Southgate?
I was at the La Quinta.
No,
And
ma'am, I don't want a factual history.
took-
I would
I
like to,
took-
excuse me, only one of us can speak at a time.
Ma'am,
I do not want a factual history. I just want to know what the status of the case is.
pending,
Okay, were you arraigned in that matter?
yes.
And do you have when's your next court date?
I don't remember right now. I think it's the 16th or the 26th. I can't remember.
Okay. And if you're to test right now, is there anything in your system other than alcohol?
Marijuana, maybe, but that's it.
Okay, well, it appears though you have a local warrant out of Southgate because you didn't show up for your court date.
I believe South. Okay, well, take me to Southgate.
I'm sorry, what? You don't tell me what to do, ma'am.
Well, I've been trying to go, but they said they didn't want me. They said they didn't want me.
Okay, well, I don't know about that. All I know is that it's alleged that you're laying in a flower bed and somebody thought you may have been dead.
I called the police myself. I called them myself.
Excuse
And
me.
then someone, I'm sorry.
Excuse me. I'm not gonna have you speak about any facts of the case, ma'am. Okay?
Okay.
So, it shows you had a high level of alcohol in your system, ma'am. Given the fact that you have a history of failing to appear, that there's a warrant for, out of Southgate because you failed to appear, and given your criminal history as it relates to alcohol consumption, the court is going to order a $5,000 10% bond with the following bond conditions. You are not to possess or consume any alcohol or drugs unless prescribed, and you're not to be released by an alcohol tether through the Wayne County Jail.
Okay, thank you.
Have a good day.
You too.
Okay. All right, let's go off the record for a moment.
Christina Sewell and Jeremy Azuara, file 26-20305-PP, set for a motion hearing. You see Ms. Sewell. I do think I can see Jeremy at this point. Mr. Azuara, I'm seeing on top of your hood, whatever that is. I'm not even sure where you're at.
I'm here. I'm parked in my vehicle, sir.
Well, I'm going to need to be able to see your face in the screen. Much better.
Sorry.
Thank you. All right, Ms. Sewell, this is your motion to modify the personal protection order. What is it that you want the court to do and why?
It was suggested after our front of the court hearing to modify it so Jeremy would have a way to communicate with our daughter. So that was the only reason why I was modifying it, because referee has legal was suggesting to modify that for communication purposes.
And how do you want it to be modified? What do you want it to say and how do you want to do it?
If I have to be honest, I have my reservations just because of what we've been going through. I just don't want a harassing amount of phone calls and text messages to Liliana, because we are in the process of trying to do reunification counseling, and Liliana's been doing her own counseling for a while now, and we've been kind of working through a lot of things. But I don't want this to regress her, because she does not want to actually speak to her dad right now.
How old is your daughter?
She's 9. She'll be 10 in July.
PPO is as to you, is that correct?
Yes.
So it does not prevent him from talking to his daughter?
Correct.
All right. So the only issue would be, how is he going to get a hold of you to set up parenting time issues for the daughter? Is that correct?
Yes. And I'm fine with him calling. Originally, he was supposed to get her phone to Liliana. He was supposed to scrub it or factory reset it and somehow get the phone to us, but that never happened. So I'm okay with him calling or trying to set up a phone call via text. I just don't want it to go excessive.
All right. Do you have an app on your phone that you would like to use? There are apps such as, I think it's called App Close, that I've heard of parents using in the past, which allows it's, and I don't know the advantage of the app over just normal texting, but I think it has a feature by which you can screenshot and take pictures of the text messages for proof purposes in the future. If you aren't familiar with that, I'm fine with normal texting. That has the advantage of still being capturing what is exactly said between the parties, which can be brought into court later and proven as to what was said and when it was said and who said it, which is the major thing that the court prefers, is to have some record of those kinds of things. Using the telephone, people say things and there's no record of anything at that time. Mr. Azuara, what do you prefer?
Well, like she said, my daughter has her own phone. I'm working on getting it. I was going to get her phone to her on when we first go to counseling. I've never harassed her. I mean, even when she had her phone, it was maybe a 5-minute conversation on the weekends just to say hi.
I'm not asking you, Mr. Azuara, I'm not asking you to redo the PPO. I'm simply saying, what type of messaging service would you prefer?
She can email my mom for things and relay messages through that way. Like I said, my daughter's 10. If I pick her up from school, Mom, if there's anything we need to know, she can simply put it in a little note and put it in her backpack. I know all her healthcare providers, so I can always call and get appointments. I usually the ones that set that up. I mean, so I'm fine without going any further things. I have no intention of communicating with her, with the mother. I mean, everything's pretty cut and dry now that she's going into 5th grade next year. My mom has worked talking with Christina in the past. They do communicate. My mom has no problem relaying email messages. I mean, that's really all I have to say about that. The only thing I would like to modify is to get my firearms back. The sheriff never took it. They just told me to stash them with a friend or a family member. I have no history of violence or criminal record. It's coming up on camping, hiking season. They're for self-defense only, and I just want my firearms back. Other than that, whether it gets modified or not, I can do everything through my mother or Liliana. She'll have her phone back. There's after 7 years, there's nothing positive that's ever come from the mother and I communicating. I don't see it changing anytime soon. So I really don't care if it gets modified or not. I mean, if anything I need to tell her, I can just email my mom and say, relay this. And
all right.
That's
Ms. Sewell, under those circumstances, do you still want to have the PPO modified?
If it is strictly for Jeremy and Liliana to have a relationship, that's fine. But I personally, we're really in the thick mud right now because she does not want to talk to her dad at all. So again, I don't want him
There's nothing that requires her to talk to him, but there's nothing that prevents him from talking to her. So the PPO is the only thing that I have in front of me. PPO says no contact between the two of you. he's telling me he doesn't want to have contact between you. So that doesn't appear to be a reason to modify the PPO at this point. Is there anything that you want to be able to tell him on occasion that you need to have? Well, the PPO isn't against you, so I suppose you could do whatever you need to do. He's the one that's going to get in trouble if he contacts you. So it appears to me there's no need to modify anything. He doesn't want to have contact with you. I can't make him have contact with you. You're still able to, if he sends you harassing messages, you're able to enforce the PPO. So it appears that you can do whatever you need to do. He's not going to be able to talk to you. And he appears to be fine with that. So at this point, I'm just going to say leave the PPO as it is. If he wants to talk to his daughter, he can make those arrangements. If you don't want him to talk to her, or she doesn't want to talk to him, that's your prerogative as a mom, and he can take that up with the child support, or excuse me, with the parenting time and custody issues.
Okay.
All right. So case will be the motion to amend the PPO will be denied for those reasons. All right. That's all for today. Thank you very much.
Thank you. Have a good day.
You too. Next matter is Nigel Ingersoll and Cassandra Ingersoll, or Cassandra Varon, file 23-19438-DM. We have parties for that case. I do see Mr. Ingersoll. I do see Ms. Ingersoll as well. This looks like an order to show cause for contempt on custody and parenting time issue. Mr. Ingersoll, is this your?
It is, Your Honor.
Request? All right. Why don't you go ahead and tell me what it is that you want and why you want it?
I would like some makeup time done in June. I came to court with you because I filed a motion to change my parenting time and custody. At that hearing, we established visitation, and I made a trip to Tennessee to see my daughter. I called in the morning. Long story short, she dodged me on one of my days. I drove all the way to Tennessee, and she acts like she can just control how the court is dictating our situation. And I spent a lot of money to go down there, and I got dodged on my time, and I don't think that's cool. And I think that I'd like to give it the court's discretion to somehow make this up to me.
Well, tell me in a little more detail what time you spent with your child and what time specifically was kept from you.
Well, the first day I didn't get to see her at all, and then the second day we did go to that cool little dance party in the caverns, which was super awesome. I've got I don't know, four maybe 5 hours with my daughter, and then it ended in an argument and my daughter's mom saying things in front of our daughter and her other daughter that she definitely should not have been saying in front of children. So she dictated my first day and we agreed on it. And then I only got a few hours the second day. We agreed on a time, and I drove all the way to Tennessee. And it takes me 10 hours to get there, and I got 5 hours total.
So what happened on the first day that you didn't have any contact at all with your daughter?
She dodged my calls. They went out to the park and they went out to eat, and because I stopped by the house, I drove by anyway, and there wasn't nobody there. I think Cassandra had to go to work, and whoever was with the kids who was gonna, they just decided they weren't gonna let me see my daughter. I had to make a stop, and
Did Ms. Ingersoll know that you were coming that day?
Absolutely. I called her at 7 o'clock in the morning. She answered, said that she'd call me when they get around. I sent her a text a little while later because I had a situation happening. I told her I might need a minute, and I called her as soon as I was done, and she flipped off. We got into a big argument over the phone, text wise, and she didn't let me see my daughter because
So what was the need a minute situation?
I needed to stop at the hospital. My significant other is currently she's 7.5 months right now, and there was a situation where she felt like she should go to the hospital because she's going to be a first-time mom, and as a responsible father, I wanted to make sure that I took her to go take care of this thing, and I texted Cassandra and told her, "Hey, this is what I got going on," and like we can get into it if you want. But long story short, she didn't let me see my daughter when I went down there.
Well, if you're not
Knowing that I
available to
was
see
down
your
there.
daughter because you're at, I'm sorry, Mr. Ingersoll, but if you're not available to see your daughter because you're at the hospital, how is she going to let you see your daughter?
I was available. I was available.
How's
Like I
that?
had a pit stop to make. Well, so I called at 7 o'clock in the morning. 3 hours goes by and I try to call again. I get no answer. I get a text. I say, "Hey, I might need a minute. I had to make a pit stop." Her reasoning wasn't even my pit stop. It was like either way. I mean, I guess you could let her explain it.
Yeah,
If you
can I
really
talk?
I'll give you a chance in a minute, Ms. Ingersoll. Just be patient. I'm talking to Mr.
Okay, thank
Ingersoll.
you. Yes, sir, thank you.
Please continue, Mr. Ingersoll.
So, Your Honor, I drove down to Tennessee. I called super early in the morning. She said, "I'll call you when we're ready." I had something come up. I said, "Hey, I might need a minute." When I was done with that, I said, "Hey, I tried to call. I stopped by the house. I texted, and she wanted to argue instead of letting me see my daughter." And then she let me see my daughter the next day.
When were you done with your pit stop at the hospital?
Maybe an hour and a half later.
What time of day?
Noon. Before noon.
Well, I wasn't there, so I can't tell you what day and time it was. You have to tell me.
It was noon, Your Honor.
All right. So you were available from noon forward. What contacts or attempts to contact did you have with Ms. Ingersoll to try to meet with your child?
I tried to call. I knew she was at work, but she had no problem communicating text-wise back with me. I made multiple attempts. I begged her. I pleaded with her. Like any more attempts would have been pathetic. Like I think I tried hard enough. Like, and the problem is she doesn't have control of my life, and she's doing everything she can to control every situation because that's the only control she has left.
All right. Mr. Ingersoll, I'm more interested in times and dates and facts as opposed to opinions about the other party. So if you could help me out.
we had an agreement that I was going to come down on the 30th and the 31st of March. She knew I was coming on the 30th. I called at 7 o'clock in the morning. I tried to call her back. She said they still weren't ready. And I said, "Hey, I might need a minute." And when I was ready at noon, she dodged me. They went to the park and went out for ice cream or lunch or whatever else it was. But they did that to purposely dodge me, knowing that I was down there because she was mad about it.
Again, Mr. Ingersoll, I don't need you to tell me what you think she was doing. I just need to tell me when you missed and what happened from your side, what you saw and what you heard. So is there anything else that you want to add?
Yes, that I went down to Tennessee and I didn't get to see my daughter on the 30th like we had agreed.
Yeah, I got that.
Okay,
right.
That's it.
Thank you. Ms. Ingersoll, your side of the story, please.
Okay, so my whole issue is that when we first went through this whole agreement, when we were in court with you a couple months ago, it was agreed upon that his significant other was not to be around the situation until June, when I took my daughter up there to meet her after all of this had gone down. She was not supposed to be down here. She wasn't supposed to be involved in anything. And he did call me at 7 o'clock in the morning. I answered. I said, "Give us a little bit to get ready." I got my daughter up, ready to go, all of the whole thing. And then I said, "All right, we're ready. And he said, okay, I got to go to the hospital. I said, oh, are you okay? And he said, yeah, she's worried about something. So it's real convenient that 10 minutes before he's supposed to come meet up with us, his significant other, who is not supposed to be involved in the situation at all, needs to
Okay,
go to the hospital.
Ms. Ingersoll, hang on, slow down. I said the same thing to Mr. Ingersoll. I don't need the comments about what the other side is or shouldn't be or might be doing. I just need you to tell me times and dates and places. Who did what? I don't need the comments about he's bad or he's this or he's that or his significant other is this or that. So
I'm not
just
trying
tell
to
me.
say that. I'm trying. Okay,
Go
but
ahead.
I'm telling you, sir, that it was agreed upon that his significant other was not to be involved in any of this situation until
Okay, slow down.
June. He
Slow down
chose
for
to
a
bring
second.
his significant
Hey,
other
slow
down.
down. Hang on just a second.
I did. Okay, I did.
Just you've told me twice now that it was agreed upon that his significant other would not be there. I'm reviewing Hank. I'm looking at the order and I don't see anything in the order that says that. Can you point me to something that says that?
It was said on record. It was said on record by you that his significant other was not to be involved. It says in the record, details stated on record. His significant other was not to be down here and not to be involved in any of this process until June. He was supposed to come down here by himself 4 times over the next 4 months to spend time with his daughter, not be worried about his significant other.
All right.
So he brought her down here. It caused a problem. He had to remove himself from coming to see his daughter 10 minutes before he was supposed to be here so that he could take his significant other to the hospital for 2 hours. And by the time that 2 hours had passed, yes, me and my daughter had already gone about our day and I had to be to work in a couple of hours. I didn't know whether or not he was going to show up with his significant other. I knew what the agreement was when we agreed upon it, and I didn't want to be involved in that situation. So I gave that day a rest. I said, I can't deal with this today. It's too much for me. I emotionally, mentally, physically, I can't. Like, he has caused me severe PTSD and he has put me in situations before that I couldn't get out of. And
all right.
And it makes me really uncomfortable.
Ms. Ingersoll, again, I don't need the details of why necessarily.
I understand.
I just want to know
trying to explain why. Okay, I'm just trying to explain
I-
why it made me uncomfortable that his significant other was down here. That's all I'm saying. It
appreciate-
all intertwines. That's the reason why I didn't meet up with him, because I was worried that she was with him, and it was
All right,
agreed upon that she wasn't to be down here.
What happened the second day that you agreed to allow your daughter to have contact with him?
Nothing. I went and picked him up from the hotel room. We went and did the concert as we were supposed to. Everything went fine that day up until I went to drop him off, and he wanted to bring up what happened the day prior and how I don't have control over his life, blah, blah, blah. I understand that. I don't want control over your life, but you agreed to not have her around until June. So there's no reason for her to be around until then.
So what you're telling me is the second day she was not there.
Correct. Well, she was at the hotel room. He left her at the hotel room.
All right. What prevented you from doing that the first day?
That part, though.
Mr. Ingersoll, I don't need your comments.
Yes, sir.
Ms. Ingersoll, what prevented you on the first day from, once he told you that he was available afternoon, from
because I didn't
picking him up?
trust him to not show up with her. I don't trust him. I was having anxiety, like I was having a severe panic attack
But you were able
about
to
him
do it on the
showing up
second
with
day.
her.
All right,
What?
but you were able to do it the second day, right?
Because I took a breath, yes, because I let myself relax and I took a breath, and I wasn't going to meet up with him the second day, but I made an agreement in order to prove that he wasn't just going to show up somewhere with her. I said, I will come to the hotel room. You come outside by yourself. I will pick you up. We will drive the hour and a half it takes to get to the concert with our daughter together. And then when the concert's over, I will drive you back to the hotel room. That way I knew he wasn't just going to show up with her. I made a separate agreement outside of the first day's agreement, and we didn't have an agreed upon time the first day. He just called me at 7 o'clock in the morning and was like, all right, you ready to go, bitch? Like,
Don't need the language.
Okay. Not even what I said.
Mr. Ingersoll? Mr.
I said,
Ingersoll.
who's ready? Yes, Your Honor.
Mr.
I did
Ingersoll,
not use that language.
I don't need your comments either. So both of you just need to take a breath and slow down. So here's what we're going to do. The court ordered 2 days in a row, weekend daytime visits. Through his own reasoning, he missed the morning of the first day. That's on him. Unfortunately for you, Ms. Ingersoll, it was on you that he missed the afternoon of the first day. So he's entitled to a makeup. You're supposed to have time in June here in Michigan, that there will be 5 consecutive day visits, no overnights, supervised by you or a designee. I'm going to add a half a day, 4 hours to that. So he gets 5.5 now when you're here, when he's here, when you're here in June for him to have his parenting time. You can either do that or you can give him some additional time on one of the other weekend visits that he's going to have in the state of Tennessee. Which would you rather have, Ms. Ingersoll?
I don't mind giving him extra time on a day he's down here. We've gone to the zoo since then. We've already had 2 other visits since this whole thing went down, and everything has been fine. And he's hugging me and telling me he misses me and all this other stuff.
Ms. Ingersoll, slow down. I don't need all of the additional information. The question was, do you want to do it in Tennessee or do you want to do it in Michigan? So I assume that you want to do it in Tennessee.
Yes, that would be fine.
Mr. Ingersoll, when would you like to do the additional 4 hours in the state of Tennessee?
I was wondering if we could do it in Michigan. I mean, considering she's the one that violated the day, like, can I ask respectfully why we're giving her the, like, don't you think we should be asking me? I mean, can I get a new mediator? Is there any chance that we could get another mediator? Like, you know, every time I've gone down there, it's a problem. Like, I kind of feel like unintentionally, you and the courts kind of set me up to hang out with my ex-wife, and it's ended in disaster, in arguments. And I think it's slightly inappropriate, some of the things that she brings up and says in front of the children. And I would strongly urge this court to give me an option to have an additional mediator besides just her. Like, it seems like it's pretty closed off. And, you know, I just got back from Tennessee, and this situation, you know, and,
right.
And by the way, the 5 days in June, that's unsupervised, right? Because that's what it said last time it's supposed to be. Earlier in your motion, you just said supervised by her, and that's not true. Okay, I'm done.
The court order says in a 5 consecutive day visit, no overnights in Michigan, supervised by defendant mother or her designee in June. So that's what we're going to do. The question is, when do we do this makeup 4 hours? Mr. Ingersoll is asking. Hang on, I'm not done. I'm not done. Mr. Ingersoll is asking for that to be done in Michigan. Ms. Ingersoll is asking for it to be done in Tennessee. I agree with Mr. Ingersoll because it was Ms. Ingersoll's actions that prevented him from doing it. We'll do it in Michigan. It will be added 4 extra hours to the time that he's here in, she is here in Michigan. Your request, Mr. Ingersoll, for someone other than me or some other mediator is denied I am the
No. I
judge.
don't.
Make
Your
decisions.
Honor, I don't mean you. I mean somebody to supervise the visits with my daughter. Like,
No, you are the dad. She is the mom. You have
and
to
the
get
mom is doing a
along.
bad job of momming, sir.
Mr. Ingersoll, I don't need your extra comments. You're the dad. She's the mom. The two of you got to grow up and learn how to be adults over your daughter. The two of you, if you can't, it's very obvious to me that the two of you can't talk to each other. That has to change. The only
We do,
way.
sir. Okay, hang on. I have something to say. Can I say something, sir?
No.
Oh.
It took three of you. This is the problem. The two of you can't talk to anybody. Period. No, I'm not listening to either of you anymore. That's why I muted you. Grow up, act like adults, become adults for your child. If you don't, you're going to screw her up. We're done today. He's getting 4 hours in Michigan. I'll add it to the court order. Case closed.
Your Honor, I do want to bring to the court's attention, there is an additional parenting time violation that's in the process as well with friend of the court.
I'll hear it when it gets here.
Thank you.
Oh, so it's not the end. It's not the end by a long shot, ladies and gentlemen. There's still there's still an outstanding parenting time offense or something. These two, we knew when we saw the last one a couple weeks ago. We said it's not even gonna, it will not even be that period of time, and it wasn't even a week. Has it been a week? Has it been 2 weeks? Maybe, possibly. And I still say, the way it's all set up, it's set up for him to kind of game this. All he's got to do is say that, well, both of them. It's kind of going both ways, right? She's got to say he's being a problem. All he's got to do is say that she's being a problem. It's all a headache. Ladies and gentlemen, we started off kind of light with Judge SImpson and some landlord-tenant stuff, and him being the Mitch he always is. And we got progressively worse as the night moved on and on and on. And we saw judge after judge just getting a little bit more frustrated and a little bit more frustrated. Stillwell was not happy. Buckley was incensed. I am shocked. I'm absolutely shocked Buckley did not just pull that deal altogether after that lady did what she did. Oh my good Lord. It's been one loudmouth after another, it seems. But hey, that being said, Mama Wolfie is making some very good points over here. We have an 11 a.m. show coming up. That means just a little over 12 hours, right at 13. We'll be right back here with the best of the week. And I've already got a bunch of stuff picked out. We got one guy passing out in Steven's room. I had to redact a whole bunch of crazy crap because that guy is sicko. But we're gonna watch it. We're gonna watch it. I got it nice and redacted. If you've seen it, you're gonna see it again. It's only about 8 minutes long, but I got a bunch of other stuff. I've got some civil cases. I've got some criminal cases. It's all good. It's all good. Come on by tomorrow morning for brunch with Lone Wolf Usul and the whole crew. We'll be here chatting and watching court cases all morning long from 11 a.m. Central Time until we get finished. I'm not going to say it's only going to be 2 hours because I don't know that it is. But for now, ladies and gentlemen, I am your Lone Wolf Usul. I am your humble host for these here get-togethers. I am your curator. Court gallery all the way around. I am the guy behind the wolf. I probably should do that closer to the microphone. And I, ladies and gentlemen, for now, am out of here. Y'all have a great night. Ferris Bueller's Day Off is a great movie. I just want to leave you with this little piece of wisdom. And I hope you remember, some people have no clue what they're doing. Many of them are very good at it. But some of those people are not the crew of the Artemis Integrity. Welcome home, ladies and gentlemen. It's great to have you back.